Hello, everyone. Welcome to this Wiley webinar on hiring individuals from the government, post-employment and conflict of interest laws, regulations, and policies for the executive branch and Congress.
Hi, I'm Kara Sacilotto, and I'm a partner in the Government Contracts Group at Wiley. So I'm going to talk about a few provisions that are everything that Rob has talked about obviously would apply to a contractor, but there are some certain extras that apply to contractors that I wanted to hit upon. They're not necessarily part of the standard 18 U.S.C. regime. One of them is Section 847 of the fiscal year 2008 National Defense Authorization Act. This provision requires certain high-level and procurement-focused DoD officials who leave DoD for employment with a defense contractor within 2 years to get one of those written ethics opinions that we've talked about before receiving any compensation. So this is an added, let's say, a very strong incentive to get that DAO letter so that you can go on to employment with a defense contractor afterwards and understand the restrictions that might apply to your activities. Another contractor unique provision is the Procurement Integrity Act. This is a statute that was passed in response to a pretty prominent procurement scandal in the 1980s. It has two distinct components. One of them is directed at ensuring that procurement-sensitive information is not released or obtained during an active procurement. And we're going to table that. It's certainly very important. But today we're talking about the second component, which is directed at employment issues. The Procurement Integrity Act restrictions are implemented by and detailed in the Federal Acquisition Regulation. We call this the FAR. If you don't understand what the FAR is, you can look at 48 CFR. That's its official designation, but if you want to be a cool kid, you will always refer to it as the FAR. And the PIA, unlike the NDAA provision I just talked about, it applies across government. So what I'll be talking about here with the Procurement Integrity Act, or PIA, is not restricted to DoD. So the first aspect of the PIA limitations, and I've given you the FAR citations here, is focused on employment-related contacts. So if an official involved in a procurement over the simplified acquisition threshold, so that means a procurement over $250,000 right now, is contacted by or contacts a contractor that is an offeror in that procurement about employment, the official must report that contact. They must reject the possibility of employment, or if they don't reject that possibility, say they want to go work for that contractor, they have to disqualify themselves from the procurement-related activities unless and until they are authorized by the agency to resume, either because the contractor who wants to employ that official is no longer participating in the procurement, or all employment discussions or contacts have stopped. Again, this applies to officials who are involved in procurement-related activities. So the FAR has a little bit more definition of what personal and substantial participation might mean in this particular context. So drafting and reviewing solicitations and statements of work, a very obvious kind of significant procurement-related involvement, evaluating the bids or proposals, and perhaps being on a source selection board and reviewing and approving the award of the contract. Participating personally can mean that you are supervising somebody else. There is an overlap between the Office of Government Ethics regulations that Rob has talked about and some of the PIA provisions, such as what does it mean to seek employment. Again, not a very, it's not narrow, it is broad. So the second aspect of the Procurement Integrity Act is the compensation ban. So if you are for certain former agency officials who made certain procurement-related determinations for a particular contractor, like those set out on this slide, in a contract that's valued at more than $10 million, there is a one-year ban on receiving compensation at all from that contractor. So, for example, you could see that maybe a source selection official who just awarded a $100 million contract to a contractor and then goes to work for that contractor, there's a halt there for compensation in those activities. Again, all of this is directed at ensuring the integrity of public procurements and avoiding conflicts of interest between government officials, recently departed government officials, and contractors who are trying to earn business from the government. The next issue to be aware of is not necessarily a statutory or regulatory issue. It's more of a litigation risk type issue. When a former government employee begins employment with a contractor, there is an incentive, obviously, to take advantage of their experience with the agency and their expertise in the area that they have been working with. But it is also an area where disappointed competitors in bid protests may claim that the contract awardee who employed that former government employee gained what is often called an unfair competitive advantage as a result of hiring that former government employee. So the allegations may be that the former government employee had access to some kind of non-public competitively useful information, maybe about the agency or about other competitors, or it was involved in drafting the solicitation or had access to source selection information. These can also morph and also be referred to as an organizational conflict of interest. Organizational conflicts of interest are addressed under FAR subpart 9.5. Two types that might implicate a former government employee would be the bias ground rules type of OCI. This is one where there's an allegation that the contractor participated in drafting the solicitation or the statement of work. And then the other type of OCI that one might see alleged is an unequal access to non-public information type OCI. We'll talk about OCIs again at the very end of the presentation when we talk about advisory boards. Now, I'm not saying that in all instances hiring somebody automatically creates an unfair competitive advantage or automatically creates an OCI. All of these kinds of instances are very fact-specific as to, who the employee is, what they did, when they left, what kind of position they held. But there's some, GAO case law in this area that sets out some, I've put here just really the broad brush of the GAO case law. And if you don't know why I'm talking about the GAO is the principal place where bid protests are brought. Not the only, but they hear most of them. So under the GAO's case law, which is really the HealthNet case that's cited here is sort of it's the most frequently cited one for these standards. Agencies are supposed to avoid even an appearance of impropriety in conducting government procurements. Obviously, we want the agencies to be good stewards of our taxpayer money. Where a contractor may have gained an unfair competitive advantage, the firm could be disqualified from the competition based on that appearance of impropriety. It's not that you have to find that they violated the Procurement Integrity Act. There has to be a determination that there was an unfair competitive advantage, and that determination really needs to be based on hard facts. In a lot of these cases, you will see a lot of speculation, innuendo, just, bald, flat-out statements that because John Doe worked at, agency X, John Doe must have done this, that, or the other. Well, that's speculation, that's innuendo. There needs to be, some evidence of hard facts for these things to be successful and for a disappointed offeror. And agencies can really, and awardees can manage these issues by doing fulsome investigations. Relevant facts include whether non-public information was available to the contractor, whether it was proprietary, whether it was competitively useful. A good practice for contractors is when you hire somebody and you're going to put them on a proposal team, it is a good idea to refresh yourself on any restrictions that employee had, what that employee did, and ensure that any participation that they might have in capture efforts don't overlap with anything they might have done while they were at the government.
It's been our pleasure to talk to you about hiring individuals from the federal government. Thanks again. Thank you, Kara.
Thanks, Rob.
And talk to you all later.